Well, welcome everyone. Kristin and I are really excited to be here with you today. So, we will be discussing the three simple solutions that you can put into place right now to protect your assets from any costs of nursing home care or long term care in the future. In the next hour, you're going to discover what your care options are, how to pay for that care, what good estate planning documents everybody should have, and what happens if you don't plan ahead for long term care. Now, this presentation is for you if you're unsure of how or where to receive care if you do end up needing care, or if you're scared of not being able to make your own decisions at some point, or even if you're just sick and tired of thinking about becoming impoverished by paying for long-term care. Imagine you could wave a magic wand and have a plan in place, a plan that doesn't burden your family, a plan that protects for your spouse and your loved ones, and a plan that avoids conflict within your family. And above all, gives you peace of mind. This is possible. See what our client Patricia Fry had to say. I'm sure glad I made the call. My husband had experienced some health challenges, so we knew it was the right time to put things in order financially to be properly prepared for the future. The thing I most appreciated was that they listened to what we needed and then provided outstanding guidance throughout the entire process. It was as if they developed a roadmap that we can now follow. They made things so easy. There's no one I would want to take care of us more than these people. Now, before we get too far, let us introduce ourselves. As Kyle mentioned, I'm Jenna Franks. I'm one of the attorneys at Steinbacher, Goodall, and Yurchak. I work primarily out of our state college location. Here we have my husband, Josh, our daughter, Ava, and our newest addition, Grayson. Now, to give you a little bit of background on me, I actually wanted to be an attorney since the 8th grade. At that point, I always saw an argument for either side of a situation. So basically, I drove my parents crazy because I always played the devil's advocate. But at the end of the day, I wanted to make a difference. And what better way than through the legal system? We lived in Florida for about 10 years and I practiced in multiple different areas of law, but nothing at that point really spoke to me. Then we got a phone call that both of our grandparents had been hospitalized and weren't doing well. We decided at that point we should move home and help out. In this picture, this is Graham and Pap, two of the cutest and sweetest older people that I know. They were married over 60 years. This is actually one of the last happy pictures that we have of them. Graham ended up with dementia. Pap suffered a stroke that made him really weak. Graham and Pap needed long-term care, but just like most people that we meet with, they wanted to stay at home as long as possible. By going through this process for my own loved ones, including even living with our grandparents for a year, this helped me realize how important planning is so that you have more options if you do end up needing long-term care at some point in the future. And I know, Kristin, you too have seen many of these same situations.
Yes, thanks, Jenna. Good morning. Thank you, everybody, for joining us today. My name's Kristin Daugherty. I am a long-term care planner with Steinbacher, Goodall, and Yurchak. I'm one of the few certified Medicaid planners in Pennsylvania. I'm also a certified dementia practitioner and additionally an Alzheimer's disease and dementia care trainer that allows me to train other professionals to become certified dementia practitioners. I've been with Steinbacher, Goodall, and Yurchak for 10 years now. And prior to joining the firm, I was with the Area Agency on Aging for 5 years. This is my family, my husband, Kyle, our daughter, Kendall, and my son, Kyler, our son, Kyler. This is also our variety of pets that we have, our dog, Chestnut, cat, Sprinkles, who really dislike each other, and our horses, which is my daughter's passion. But how did I get here? Well, I like to compare it to Alice in Wonderland because I kind of fell into it. I always know that I wanted to help people and work with people. So in college, I went into sociology and psychology. Initially took an internship at a drug and alcohol facility, and I knew right away that was not my calling. The Area Agency on Aging was looking for a new care manager, and I took a chance and applied for the job, and so glad that I did. I loved working at the Area Agency on Aging, going there every day and helping people, especially with in-home care. But as most of you know, like many social service agencies, resources, funding, and manpower is really limited. So that's how I ended up transitioning to Steinbacher Goodall Yurchak, where I'm able to go above and beyond every day, doing what I love most, helping families, protecting spouses, and giving the right advice. I work alongside Jenna to explore options for care, applying for benefits, connecting seniors with resources, and most importantly, advocating for those in need. But the main reason I'm so passionate about what I do is because of being able to help somebody like Nancy. Now, I'd love to tell you Nancy's story, but I think her testimonial says it all. After my husband went into the nursing home, I went to another law firm in the area to see what could be done about paying for his care. They said there was nothing they could do for me and that I'd have to spend down my money for him to then be eligible to receive Medicaid. I was very concerned and felt that like they just left me on my own. I later was told to call this firm. I figured why not, because at this point I had nothing to lose. After explaining my situation, I was told to come in right away because I required immediate assistance. What they did for me was unreal, especially after being told I was in a hopeless situation by that other firm. They took action to protect our assets and get my husband's nursing home bills taken care of into the future. Everyone was so wonderful. I'd taken my daughter with me, and when we were told that the bills were going to be paid, she cried because she knew what the other lawyer had previously said. I can't say enough about that kind of attention to detail. Now, today isn't about Nancy, though. It isn't about us. Today is about you. So our goal for you today is to tell you what you need to do to make sure that you and your loved ones are taken care of during your second half of life. What you're going to discover today, the right information, what care options are available, how to pay for long-term care, estate planning documents that everyone must have, and options for protecting your assets. We're going to take you from where you are right now to where you want to be. So let's go ahead and get started with simple solution number one, knowing what care options are available and how do you pay for that care. Let's start talking about what type of care is available. In order to put a plan in place, it's really important to be able to know and be able to think through how you actually want to receive care in the future if you need it. Now, we're really lucky in our areas to have a variety of ways to receive care. Care choices range from in-home to facility care with many options in between. Most of us want to stay home no matter what, which is great as long as it's practical and safe. There are agencies that provide in-home care services, and you can also hire individuals on your own to provide care. If you need some socialization or your caregivers need some respite, there are adult day centers that are able to provide a little additional help so you can stay home. However, at times, in-home care is not enough and facility placement is necessary. Placement options range from independent living to personal care homes, otherwise known as senior living facilities, to memory care communities, to skilled nursing homes, and even continuing care retirement communities. So let me share a little bit more information about each of these levels of care and facility options that you have. So the first, personal care home or senior living communities. These are a great option for someone who needs some supports outside of their home. These facilities provide things such as meals, medications, some supervision, activities, some assistance with medical needs, personal care needs, and some even offer memory support. Now, these communities, as far as costs go, really can range. We see some cost as little as $3,000 a month. We see some that cost as high as $8,000 or $9,000 a month, depending on what type of care you need and what they offer. Now, memory care facilities are a great option for those who have memory impairments, but otherwise are healthy. These facilities focus on memory enhancing activities and therapies, while meeting all of their residents' needs and providing a safe and secure environment. Skilled nursing facilities are the highest level of care and often have the most medically or cognitively impaired, my goodness, individuals residing there. Skilled nursing homes in Pennsylvania on average cost over $11,000 a month. So that's well over $130,000 per year. Now, continuing care retirement communities, otherwise known as CCRCs, typically encompass all of the levels of care: independent living, personal care, and skilled nursing. This is a great option for those who would like to age in place. Now, CCRCs generally only accept private pay, and the costs can range based on the community you're residing in and your level of care. Many CCRCs also have a buy-in, which could be quite large. If you think a CCRC is the right option for you, it's really important to start that process now to see if it would be a good fit and financially meets your goals. So you might be wondering, how do you actually pay for care? Well, as we know, none of this can be for free. So there are a variety of options on how you can pay for it. Of course, you can privately pay for any care you receive. However, as I just mentioned, skilled nursing home on average in Pennsylvania is $11,000 a month. So you can quickly become impoverished paying for this care out of your pocket. So if you are a veteran, a spouse, or a widow of a veteran, you may be eligible for the aid and attendance pension benefit through the Veterans Administration. This can be a benefit of up to around $2,000 a month if you meet the medical and financial criteria of the program. There's long-term care insurance, which is a great option. Every long-term care insurance policy works a little different, so you need to make sure you know what it covers if you need care. For instance, what type of care does it cover? Does it cover in-home care? How much is the daily benefit? With the average daily cost of nursing home care right now, about $364 a day, a policy that only pays out $100 a day isn't going to be good enough on its own. Now let's talk a little bit about Medicare. Most Medicare recipients believe that they are going to receive 100 days annually of Medicare coverage if they go into a nursing home. Sadly, that just isn't true. Medicare was designed as a short-term solution to long-term care. It covers up to 100 days annually. The keyword up to. Most individuals only receive around 20 days of coverage. So you can see why it's really important to have other options in place to help pay for your long-term care. Lastly, let's talk about the only permanent solution, Medicaid. As I mentioned earlier, I'm one of the few certified Medicaid planners in Pennsylvania, and I could absolutely sit here and talk to you about Medicaid all day long, but I probably put you to sleep, so I'll spare you. But did you know that most residents in nursing homes are actually covered under Medicaid? And you might be thinking, but wait, isn't Medicaid an impoverishment program? And yeah, it is. But there are strategies that we can implement to help you get qualified for Medicaid while at the same time protecting assets from your care cost. There's even a Medicaid program that pays for in-home care. Now, Medicaid planning is very complex and strategic, even for a situation that may appear to be simple. In a little bit, we're going to dive into the assets and Medicaid qualifications a little bit more in detail. But first, what I think we should do now is switch gears and have Jenna come back on and talk to us a little bit about estate planning documents and why they're so important.
Thanks, Kristen. So, the second solution to protect yourself from the cost of long term care is to have good legal documents. Typically, this would include several powers of attorney and a last will and testament. But for some people, it might also include a trust. If you guys get nothing else out of this presentation today, please get this one thing. The most important thing you can do to protect yourself right now is to put good powers of attorney in place. A power of attorney is just a written legal document where you're appointing somebody else to be able to make financial and or healthcare decisions on your behalf. But why are powers of attorney so important? Well, let's talk about the risks of not having them. If you don't have powers of attorney and something happens where you're unable to make your own decisions, then your loved ones will have to seek what's called a legal guardianship. This is basically a court process where your family has to ask a judge to appoint a guardian to be able to make financial and healthcare decisions on your behalf. Unfortunately, this process is really costly, it's time consuming, and at the end of the day, you lose control because it's up to the judge to appoint who will be making decisions for you. It may or may not be the person you would have appointed for yourself. And believe it or not, even your spouse can't just step in and automatically make decisions for you. In fact, the state of Pennsylvania assumes that you don't want your spouse to make financial decisions for you unless you've provided otherwise. So, by not having a power of attorney, you could really limit what your spouse is able to do about finances. In the worst situations, this could even end up impoverishing your spouse if you need care at some point. Now, let's dive in a little bit more and talk about the different types of powers of attorney. Keep in mind, these documents might look a little bit different coming from different attorneys' offices. They might be titled differently, but they work the same way. So, for instance, we provide a financial power of attorney. Similar documents might be titled a durable power of attorney or a general power of attorney. A lot of times, though, they work the same way. They deal with finances. So, our office usually provides four powers of attorney for each of our clients: a financial power of attorney, a healthcare power of attorney, a mental health power of attorney, and a living will. Let's talk first about the financial power of attorney. This authorizes whoever you appoint to make financial decisions on your behalf, dealing with bank accounts, handling real estate, and basically dealing with any asset or income that you have. This would also authorize this person to deal with the monthly paying of your bills, simple things like that. But obviously, it could deal with bigger things like selling or purchasing real estate, for example. Unfortunately, not all powers of attorney are created equal. Our office tends to see power of attorney documents that don't include everything that's necessary. For instance, if you do have a financial power of attorney, check it. Make sure it authorizes the person to make unlimited gifts and create irrevocable trusts. It can't just say gifting in general or trusts in general or even limited gifting. It must say unlimited gifting and irrevocable trusts, or else your power of attorney could be very limited in protecting any of your assets if you end up needing care in the future. And that's something that we can review with you at our office as well if you're not really sure whether your power of attorney is actually good enough or not. Now, if you do have a power of attorney and you signed it before 2014, it would be a great idea for you to have an elder law attorney review it to make sure that it still includes everything that it should. The reason being is the law changed in 2014. And now, unfortunately, the documents have gotten much longer because the law now says if it's not spelled out in the document that your power of attorney can do something, then they're not allowed to do it. So everything must be spelled out within the document. Nothing is assumed. So just to give you guys an idea, powers of attorney maybe 10 to 15 years ago might have been 3 to 4 pages and it included everything. The person you appointed could basically just take that document and do anything that they needed to on your behalf. Now we've separated that into four different powers of attorney. Our financial power of attorney alone is about 20 pages. So obviously things have gotten a little bit more complicated and the documents have definitely gotten a lot longer. Next, we have the healthcare power of attorney. This authorizes the person you appoint to make decisions like who your doctors would be, what hospital or facility you could be treated at, and it's HIPAA compliant so that your power of attorney can talk to your doctors and access medical records so that they can make good decisions on your behalf. It's important to note too that as long as you're able to make your own healthcare decisions, you have the right to make those regardless of what these documents say. But at some point, if your doctors would say that you're not able to make your own healthcare decisions, that's when these documents would take effect and your power of attorney could start making those healthcare decisions for you. Next is the mental health power of attorney, and this is a newer document in Pennsylvania. This allows your power of attorney to make decisions like who your mental health doctors would be, what mental health facility you can be treated at, and it also addresses treatments that are specific to mental illnesses. For example, most forms of dementia at this point do not have a cure, so all we have are labs, studies, and medicinal trials to try to slow the progression of the illness. Most of these forms of treatment have not been proven yet. They're experimental. So they're sort of in a gray area. For your power of attorney to be able to say yes or no to you being involved in that type of treatment, you have to have a mental health power of attorney in place. If you don't, your power of attorney would not be able to say yes or no to you being involved in those types of treatments. Those types of treatments would basically not be an option. Now, the thing with the mental health power of attorney, though, is that it does, by law, automatically expire 2 years after you sign it. This is the only estate planning document that has an automatic expiration date like that. And that's because it's a newer document in Pennsylvania, and the government basically wants to protect you and make sure that the people that you're appointing for mental health decisions are still the people that you would appoint 2 years later. The unfortunate side of that is that 2 years is not a long period of time. So you do want to keep up with that and make sure that if this is a document that interests you, you do update that every 2 years. Last, we have the living will, which is also called the end of life document. The living will applies if the doctors are saying that you are in an end of life situation, such as a permanent coma, a permanent vegetative state, or you have a terminal condition, so you have about 6 months or less to live, and you're not able to make your own decisions at that time. If you do find yourself in one of these end of life situations, basically at that point, the doctors are saying there's no hope of recovery. No matter what treatments you undergo, there is no hope of recovery in the long run. So, if you are in one of those end of life situations, the living will addresses what types of life sustaining treatments you would want, such as breathing machines, feeding tubes, chemo, dialysis. Most clients that we meet with don't want these types of treatments if the doctors are saying that they are end of life regardless, but those are very personal decisions. The one recommendation that we do make is that you at least allow what's called artificial hydration. It's water. We recommend that you at least allow water through an IV so that you can receive pain relieving drugs so you're comfortable and not suffering. So that's the one recommendation that we make. Otherwise, all of these decisions are very personal, and it's up to the client in particular. A common question that I get is, what is the difference between the powers of attorney and the executor in the last will and testament? Powers of attorney are only effective during life. Then, once the person passes away, the powers of attorney are no longer in effect. It's the will that we're looking at then, and the executor listed in the will would now be in charge. Trusts are typically effective both while the person is living and for at least a few months after the person passes away, but this could all be different depending on what the terms of the trust are and how it's set up. Most of us know that the last will and testament states where your property will go once you pass away. You will appoint an executor or a personal representative who will administer your estate once you pass away. Basically, pay your debts and expenses and make sure the rest of your money goes to the beneficiaries that you've designated in your will. If you do have minor children at the time of your death and the child's other parent is not living either, you can actually appoint a testamentary guardian for your minor children within your will. Or if any of your beneficiaries are minors, maybe grandchildren, if they're minors when you pass away, this could pose a problem because we cannot directly give inheritances to children under the age of 18. But what we can do is we can actually appoint a custodian within your will who could then monitor the child's inheritance until the child does reach the age of 18. Then, once the child would reach age 18, they can take over their own inheritance, and it would be theirs. There would be no more custodian. So, your will can actually do a lot more than just say where your money's going to go. There could be a lot more that comes into play. A will should be what's called self-executed, meaning it should be signed in the presence of two disinterested witnesses and a notary, and none of these individuals should be related to the person signing the will. It's common for married couples to create what we call I love you wills. This is when their wills say, if I pass away, everything goes to my spouse. One big recommendation that Kristen and I make for clients who are concerned about long term care costs is what's called the bypass clause, which basically says if I pass away, everything goes to my spouse. But if my spouse is institutionalized in a nursing home, I don't want all of our assets that we've worked hard for to go straight to the nursing home. So instead, let's bypass the spouse and have everything go to the next line of beneficiaries, whether that's your children, nieces and nephews, relatives, friends, whoever that might be. Now, just a little disclaimer about that. You do have to keep in mind that in Pennsylvania, you can never completely disinherit your spouse. Your spouse is always entitled to what's called a spousal election, which is basically 1/3 of your estate. Even if your spouse is okay with you bypassing them because they're in the nursing home, chances are that the nursing home will try to force your spouse to take that spousal 1/3 share. But even if that's the case, including that bypass clause would still protect 2/3 of the estate, which is better than not protecting anything. It's better than having everything go to the nursing home.
Does a POA allow access to and changing accounts such as LinkedIn, Facebook, and other social media?
That's a good question. So there was actually new laws implemented as far as digital assets go. So all that online content, whether it's like social media accounts, like was mentioned here, whether it's online banking or email accounts, all of that was addressed by the new digital assets law. So now a power of attorney is able to actually deal with digital assets like that. So yes, yep, good question. Now, keep in mind that not everything passes through your will. If you have an account that has beneficiary designations, such as life insurance or retirement accounts, that account will pass to whoever you have designated as the beneficiary, regardless of what your will says. Same if you have an investment account or a brokerage account that has a payable on death or a transfer on death designation. These work just like beneficiary designations. So whoever you appoint on those accounts as the transfer on death or payable on death, that's the person who will receive the money when you pass away, regardless of what your will says. Now, real estate is basically its own can of worms. It all depends on how the title to the property is held. Typically, if a married couple owns a property together, they automatically hold it as what's called a tenancy by the entirety. This means that if either spouse would pass away, the entire title to the property automatically legally passes to the surviving spouse 100%. No new deed is necessary. It automatically happens. And it's very similar if one or more people own a property as what's called joint tenants with the right of survivorship. If one of the owners would pass away, that person's title is automatically legally transferred to the surviving owners. Now, if you hold title to real estate with someone else as what's called tenants in common, this means that if you pass away, your share of the property will pass according to what your will says. So it's important to know how you hold your property in order to tell what's actually going to happen to your interest in that property when you pass away. If the first place that I would recommend looking is your deed, and if you're not able to tell, I would recommend that you take that real estate information and the deed to an attorney who could then tell you how you hold that property and what would happen to your interest in that property if you passed away. Ultimately, it's essential to know who your beneficiaries are across the board so that your estate plan makes the most sense. Know who will receive all of your assets if you pass away, or even if you needed long term care. All right, let's talk a little bit about trusts. But don't worry, I'm not going to bog you down with all the dirty details about trusts because let's face it, it's not the most exciting topic. But we did think it would be important to touch base on because I'm sure many of you have heard from someone that put their house into a trust, or you've even seen in the newspaper that someone sold their house to a trust for $1. So what is a trust? A trust is just a written legal document that lays out rules. The rules say who will be in charge of the trust assets, how the assets can be used, and where the assets will go over time. In order to get assets into the trust, we actually have to transfer them in. So for real estate, we would need a deed transferring the property into the trust's name. Or for a bank account, we would have to actually go to the bank and open a new bank account in the trust's name. Same for all other assets. If we're transferring them into the trust, we have to actually work with the financial institution or whoever holds that property or holds that asset and actually get the asset transferred into the trust name. The trust names one or more people to be in charge of the trust. These would be the trust managers. We call them trustees. They're the people in charge. The trust also names the people who will receive money or distributions from the trust. These would be the trust beneficiaries. Keep in mind, there are so many reasons for setting up a trust. There are also a lot of different types of trust, just to make this even more complicated. For instance, you might have heard of revocable and irrevocable trusts. Anytime Kristin and I are trying to protect a client's assets from the costs of long-term care, we always use an irrevocable trust. In Pennsylvania, only irrevocable trusts offer protection against creditors like the nursing home or the state. However, we would use a revocable trust if we were just trying to avoid probate, or if we're trying to avoid federal estate tax, or if we're dealing with a blended family. Revocable means that the assets we put into the trust can easily be moved back out, and the terms of the trust are very easy for you to change. Irrevocable sounds a little scarier, and it is more difficult to get the assets back out of the trust if you need to, and the terms of the trust often can't be changed as easily as a revocable trust could. But believe it or not, Kristin and I deal with these irrevocable trusts day in and day out, and you still have a lot of power and flexibility, even if some of your assets would be put into an irrevocable trust. Just to give you one example, if you put your home into an irrevocable trust, you would still have the sole power to sell it. So you could still sell your home at some point. You could even use those proceeds to purchase a new home, maybe if you wanted to downsize. So still a lot of power and flexibility, even with an irrevocable trust. So please don't hear that irrevocable word and get scared, that we're tucking assets away and you're never going to be able to access them. That's not how this works. Why do we use trust though? Why not just outright gift some of these assets to children or relatives? Kristin's actually going to address more on this shortly, but by using a trust, you get to keep power and control over your own assets. You don't have to worry about your children spending the assets or maybe losing the assets if your child would end up getting divorced. By using an irrevocable trust in particular, you get to keep your assets, but also protect those assets from possible long-term care costs. So it's a win-win for a lot of these situations, especially if you would end up needing long-term care at some point in the future. All right, so what do you need to do? Your first step to get these valuable legal documents is to meet with an elder law attorney. Elder law attorneys are the attorneys that you will deal with for many of your second half of life situations, retirement, planning for care at some point, or even planning in case you would pass away. So meet with an elder law attorney to review any current documents that you do have right now. Get good powers of attorney if you don't have them, because remember, this avoids putting your family in a bad situation, such as guardianship, impoverishing your spouse or your loved ones, or even a family feud within your family. John and Denise Satzler were in your shoes before they met with us. Afterwards, they said, "Thank you so very much for the exceptional services. The financial investment we made in your firm is suitable, for we now have peace of mind in regards to our estate planning." All right, let's go ahead now and move on to the next solution. Kristin's going to talk with you about why having an overall plan and acting sooner rather than later is so important. Kristin?
Okay, thanks, Jenna. All right, so we're going to switch gears here. And in this next section, I'm going to talk to you about why it's so important to protect your assets from long-term care. So do you know that if you do not put a plan in place and need care, the state of Pennsylvania or the nursing home will tell you that you need to spend every last penny on your care, or that you may lose your house to the state of Pennsylvania? We work with families every day to make sure they do not lose their house or their life savings, all while protecting what's most important, their spouse and families. But what is long-term care planning? It's the process of planning for your future while you are still able to make a plan and understanding what options are available and the costs involved. By planning before you get sick, you can control what happens. So a little bit earlier today, we talked about care options and how do you pay for care. But if you do need care, what's available? What can the nursing home or the state force you to use to pay for your care? Well, the reality is almost everything. This includes bank accounts, CDs, investments, life insurance, retirement accounts, real estate, pretty much everything that you own. And guess what? If you're married, your spouse's assets are available for your care too. Doesn't matter how they're titled. So how do you protect your spouse? Well, here in Pennsylvania, we're pretty lucky as we have fair spousal impoverishment rules and can protect almost everything for the spouse that doesn't need care. But if you do not have good powers of attorney, as Jenna mentioned earlier, we can be stuck and potentially not able to protect any assets, even if they are jointly owned. So what about your house? For most of us, our house is our most vulnerable or valuable asset and vulnerable. The good news is with proper planning, there are options available to protect your house, even if you need care right now. If you do not protect your house and need care, the state of Pennsylvania will place a claim against your house either when you apply for care or after you pass away. So how do you protect your assets? Well, every plan is different. It depends on your goals, family situation, where you're receiving care, how much care is needed, your assets, and your income. There are many variables that we need to take into consideration when we are putting a plan in place. I always compare it to a puzzle. We have to put the entire puzzle together to do a good job. If we're missing pieces, you have an incomplete plan. There are many tools that we use to protect assets, but probably the two most have heard of are irrevocable trust, as Jenna mentioned a few moments ago, and also Medicaid compliant annuities. I'm not going to spend too much time talking about Medicaid compliant annuities today, but if you need care or you're planning to protect assets against your potential future care costs, it's important to know that we will likely use irrevocable trust or Medicaid compliant annuities or a combination of both. So I just mentioned irrevocable trust and annuities. So you might be thinking, but wait, how can you make gifts and then qualify for Medicaid? Well, there is a 5-year look back when you do apply for Medicaid. This is the 5-year period prior to your Medicaid application being filed. During these 5 years, the state wants to ensure that you have not gave away any assets over $500 a month. It's not $12,000, it's not $15,000. Those are tax gifting rules. For Medicaid purpose, a gift is anything over $500 a month. Now, if you have made gifts, the state will total the gifts and issue a period of ineligibility. So let me clarify something. Just because you have made gifts and need care within the next 5 years doesn't mean that you actually will not qualify for Medicaid. There's just a period of time that Medicaid will not cover you because you've made gifts. So there's a process though, and it must be done perfectly to start this penalty if you've made gifts in the last 5 years. So let me give you a quick example. You gave away $100,000 or a house valued at $100,000 or a $100,000 check, whatever it may be, and then need care within 5 years, the state of Pennsylvania will issue a 9-month ineligibility period. We come up with that figure by taking the total gift of $100,000, dividing it by the average cost of care in Pennsylvania, which is $11,000. So for 9 months, the state of Pennsylvania will not pay for your care. So if you have enough other funds to privately pay for your care for 9 months, then that's fine. You can protect the gift, but you're going to pay for care for 9 months. But what if you do not have enough money to pay through the gifting penalty? Well, then there's a lot at risk, such as not qualifying for Medicaid, not being admitted into a facility, or even filial responsibility, which means your children can be held legally responsible for your nursing home bills. I do not know many people who would want to put their children in that position. So lastly, we must mention that we do not recommend outright gifting to anyone, even if it's your children and you love them very much. That's because of what we refer to as the 4Ds: divorce, debt, disability, or death. Let me give you an example. You gift $100,000 to your son and he gets divorced. Well, that $100,000 is now part of the divorce settlement. You gift $100,000 to your son and he has creditors. Now that money is available for his creditors. You gift $100,000 to your son and he becomes disabled. He may not be able to qualify for the benefits he needs. Or what if, God forbid, you gift $100,000 to your son and he passes away? So what do you do? What can you do to prevent any of that happening to you? You can put a plan in place. By putting a plan in place, you control what happens if you need care, who makes decisions for you, and ultimately the outcome. Now, I know the last section was a little overwhelming and scary, but think about this. Do you want somebody else making these decisions for you? Do you want to burden your family by not having the conversation or not having a plan in place? Of course not. Let's go back to Nancy. Nancy didn't have a plan. She was told that there was nothing that could be done. She was hopeless and felt like nobody was on her side. Thankfully, her friend told her to call us and we were able to jump into action and help her. But what if her friend didn't tell her to call us? She would have lost everything: her house, her income, her assets, and probably her will to keep moving forward each day. Do you have a friend like Nancy? Maybe, but maybe not. Do you want to leave it up to chance? Of course not. So what do you have to lose? Think about that for a minute. What do you have to lose? Now, while you think about what you have to lose by not putting a plan in place, let's recap what we've discussed today. How to keep the nursing home from taking your home, what options you have to pay for care, what happens if you do not have good estate planning documents, and what happens if you do not put a plan in place to protect your assets. After everything we've talked about today, I hope you get this one thing. Planning ahead is essential to make sure your family is taken care of and that you do not spend any more than necessary on long-term care. How do you make that happen? How do you get from where you are right now to where you want to be? By scheduling a long-term care strategy session. How does that work? What is that? It's a 1-hour strategy session with our office via Zoom or a telephone call. During our time together, we will ensure your estate planning documents are in good order. We will develop a plan for your second half of life. Plus, we will answer all of the questions you have about your unique situation. At the end of our time together, you will know what documents you need. You will know your options for long-term care, and you will have peace of mind knowing that you and your loved ones will be ready for the challenges of tomorrow. After our meeting, we will develop a written plan with recommendations. We will work with you to implement the plan, prepare any and all legal documents necessary, and most importantly, we will walk you through this process from start to finish. Now, you might be wondering, well, how much does this cost? Well, the value of this strategy session is $495, but we feel like it's really important to be able to offer this to you today for free. By scheduling an initial consultation, we will walk you through everything that you need, and we are offering that today for free. But what's the catch? Why are you offering this for free? How is this gonna help? Well, here's the catch. There really isn't one, but I will tell you, we are scheduling normally initial consultations about 6 weeks out or so. We've set aside times to get with you sooner. We have opportunities as early as next week to meet with you because we know you're attending today because this is on your mind. You're curious, you're wondering. We're here to help get you through this process quickly and to answer all of your questions. So how do you book your strategy session? Well, a couple different ways. One, you can go right now to chatwithsgy.com. Kyle's also going to be putting that in the chat box right now. All you have to do is click on it. It will take you to a website. You can select Williamsport office, State College office, and your times come up and you put your name in and it's done. It's that easy. We have designed this to be so easy for you. You can also call us at 800-351-8334. Remember, by what you will know during that strategy session, your options for long-term care, including how to protect your home from the nursing home and protecting your assets, what documents you need, and you will have peace of mind knowing that you and your loved ones will be better prepared for the challenges of tomorrow. One more time, here is the link if you want to go to chatwithsgy.com or call our office to schedule that free strategy session. Okay, so with that, I'd like to thank everybody for attending today. We hope the information was helpful. Please take advantage of that strategy session. We'd love to talk to you and meet with you and about your situation and see what we can do to help.